I'll try and guess.
Call meeting to order. Good evening. This is the regular meeting of the municipal land court for River Edge, Wednesday, February 25th, 2026, time now 7:32 p.m. This meeting of the municipal land use board for River Edge is being held both in person and remotely via Zoom in compliance with the provisions of the Open Public Meetings Act and associated regulations. Notice of this hybrid meeting was published in the Berlin Records, posted at Borough Hall and posted on the borough's website. The notice included the dial-in and login information necessary for public participation and access to this meeting remotely. Copies of the agenda for this meeting are made available on the borough's website near the posting of the meeting notice and includes the dial-in and login information. This time, kindly silence all cell phones. During the public comment period of this meeting, if you would like to make a public comment, you may step up to the microphone. If there's one that waits to be recognized by the chairperson, or you can press the raise hand button on Zoom or dial *9 on your telephone keypad to raise your hand. You may mute and unmute yourself by pressing the microphone icon on Zoom or dialing *6 on your telephone keypad. You must state the name and address clearly prior to making a public comment. That, I'll ask this.
Thank you. Mr. Mayor?
Here.
Mr. Casson?
Here.
Mr. Craig?
Here.
Ms. Boland? Here. Mr. Gibbons?
Here.
Mr. Canigo?
Here.
Mr. Salva?
Here.
Mr. Gautier?
Here.
Okay. Miss Councilman Glass?
Here.
And Ms. Levine?
Here.
All right. Also present, we have our board planner, Mr. Behrens, and our board engineer, Mr. Costa.
It's time to all rise. Hold the meeting. United States of America.
And
to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, this time before we get into our agenda for this evening, one housekeeping matter that will be a curfew this evening. This time, our first agenda item is under the notice to approve, we'll move to discussion items. First item up is the appointment of conflict counsel. That is Mark Weedman of the CSP law firm.
yes, my firm has a conflict on a recently submitted application for Pacific Outdoor. And so we prepared another resolution like we did for this current billboard application for Mark to handle.
Okay.
All the terms are the same.
Any questions from the board? Also,
We could do a roll call vote. Yep. We need a motion.
you don't, a second?
Second.
Mr. And Mr. Mayor,
Yes.
Mr. Casson,
Yes.
Mr. Craig,
Yes.
Ms. Boland. Yes. Mr. Gibbons,
Yes.
Mr. Canigo,
Yes.
Mr. Salva,
Yes.
Mr. Gautier,
Yes.
Councilman Glass,
Yes.
and Ms. Levine.
Yeah.
Okay, the motion passed.
Okay, thank you very much. Second item, this evening, discussion items. Continuation of the public hearing, it is the public hearing on the amended housing element and fair share plan. At this time, I'd like to turn, over to our planner, Barretts.
Good evening, Mr. Chairman, board members, and the public, just give me a moment and, get the brief PowerPoint presentation.
And I'll just swear you in, Tom, for the record.
Yes.
Please raise your right hand. Do you swear or affirm that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thanks.
Thank you. Again, good evening. My name is Tom Behrens. I'm the borough planner with the firm Burgess Associates. I'm here this evening to assist the land use board in conducting its public hearing on the borough's 2026 amended housing element fair share plan. As the board will recall, the board adopted a housing element fair share plan in June of last year, on June 25th, to address the borough's fourth round state mandated affordable housing obligations. And as we work through the compliance process, we've had to make a few updates, which I'll explain momentarily. And in general, the whole goal participating in such a process and trying to achieve what's known as compliance, is to preserve the borough zoning ordinance essentially. And that for the 10-year compliance period beginning in July 2025 to 2035, assuming the borough gets certification, compliance certification, it'll be immune from what's known as builders remedy lawsuits, whereby if the borough didn't have immunity, a developer could come pick a site and essentially sue the town in order to build affordable housing, because the town theoretically would have the plan to meet. So this avoids all that. Again, we get a compliant certification based on our plan. We'll be able to preserve our zoning and again, be immune from those types of situations. And I would just state that the plan in general, on the one hand, one goal is to achieve compliance, and the second being to minimize impacts to the borough. So we looked at sites deemed to be most appropriate and mechanisms that I'll get into in just a moment. So without getting into the full history of affordable housing in New Jersey, which for 50 years municipalities have had to address their what's known as their fair share of affordable housing, and that process has evolved. Again, we are at the beginning of the fourth round, which began again in July of 2025, lasts for 10 years, whereas the first round began in 1987. And we are operating under a new legal framework, which, as this slide implies, on March 2024, the state legislature adopted amendments to the State's Fair Housing Act, which was originally enacted in 1985. So this March amendment was really a wholesale reorganization of the regulations, created a whole new framework and compliance process, a new methodology for how municipal obligations would be calculated, and mechanisms for towns to satisfy their obligations. So it was a bit of a learning curve where all participants had to figure out what all this meant in essentially a short period of time, beginning with the Department of Community Affairs, which was responsible for calculating statewide affordable housing need numbers, which it met by the October 2024 deadline. And the way it works is that DCA was in charge of, again, creating the state obligation, which it calculated as at about 85,000 affordable units statewide. That number then trickled down into regions. The borough of River Edge happens to be in Region 1, and then that regional number was divided into individual municipal obligations, and I'll explain what ours was momentarily. So following the assignment of numbers, municipalities had to accept their numbers no later than January 31st, 2025, so just about a year ago. That number could have been challenged. Ours wasn't, because we accepted that the math was correct. It was fairly straightforward in River Edge's case, so not an issue there, but we did have to adopt a plan no later than June 30th of 2025, which again, this board did on June 25th of 2025. By August 31st, the legislation allowed for any challengers for any reason to challenge with specific particularity any municipal affordable housing compliance plan or housing element fair share plan. River Edge did have one challenger, by the way, a Fair Share Housing Center, who's the state's affordable housing advocate. I'll note that they also challenged over 420 municipal plans. So pretty much everyone got challenged to participate. I'll note that I think Teterboro came away unscathed, but other than that, most other towns did have some form of challenge. I would say ours was fairly benign and generic. Nevertheless, we had to work with them through what's called the Affordable Housing Dispute Resolution Program, known as the program for short. So the way that program worked was the municipality would have to try to reach an agreement, mediate with any challengers. Again, in our case, it was just Fair Share Housing Center, and meet with the mediators being retired Mount Laurel judges, as well as an assigned special adjudicator, which is usually a licensed professional firm. So having worked through that process, we were able to achieve a middle ground with Fair Share Housing Center and executed a settlement agreement with them, we meaning the borough, in January of this year, having received input from the council along the way. And the next step of the process, the reason that we're here tonight, is to essentially implement the terms of those agreements and what I would categorize as adjustments to the June plan that was adopted. And once we adopt these adjustments to the housing plan, the borough also has to adopt the implementing ordinances no later than March 15th. So it's anticipated that those ordinances will be introduced tomorrow night.
I believe so, at the Borough Council meetings tomorrow.
That's correct.
Yes.
Correct. And then this board at its next meeting, the date of which escapes you, will conduct master plan consistency review on those ordinances. and then the Borough Council will adopt the ordinances by the deadline. So we will have, that by then, met our statutory requirements, after which the assigned vicinage judge, which is different than the program judge, will review our case essentially, and hopefully we'll be in their good graces and get a compliance certification, which again gives us immunity and preservation of our zoning ordinance for the next 10 years. So without further ado, I'll give an overview of the plan, how we complied. I will note that anyone that's interested in the history of Mount Laurel and affordable housing in New Jersey, there is about a 2-page overview within the plan, which is posted on the borough website. If you search affordable housing on the borough website, it has both the June plan that was adopted and this plan that's up for adoption tonight, as well as some other of the borough's prior affordable housing documents. So without further ado, I'll go over the borough's fair share obligation, as it's called. Again, the Department of Community Affairs, DCA for short, was assigned with tabulating municipal affordable housing obligations. In this case, there are essentially 2 obligations where the borough was given a present need, or what's known as a rehabilitation obligation of 32 units. Those generally pertain to the rehabilitation of existing units. And we had prospective need obligation, which generally pertains to the creation of new units of 159 affordable housing units. So while those numbers sound like a lot, I'll explain how we're able to manage those. So first of all, the statute allows municipalities to conduct what's known as a structural conditions or windshield survey, whereby municipality can, really take a look at what exists in the town to see which units, if any, qualify for rehabilitation. And so that analysis was done in accordance with, or in collaboration with the borough's construction official. And so the borough's present need or rehabilitation obligation was adjusted from 32 units to 7 units. In addition, the borough, being essentially a fully developed municipality, is entitled to what's called a vacant land analysis, where, again, you can review the larger number, in our case, 159 units, and see if there's any adjustments that can be made based on the lack of vacant land. We did have the 3rd round, that was for the period 1999 to 2025. The statute allows us to rely on that prior analysis, that analysis yielded that we essentially had no vacant land. And lo and behold, the borough didn't create any new land, and there were no new vacant sites that would qualify as vacant land in this 4th round analysis. So it turned out that our realistic development potential, as it's known, or that adjusted number, again yielded an RDP, a realistic development potential of 0 units. So I'll reiterate. So that the state assigned number from DCA of 159 was essentially adjusted downward to the RDP of 0 units. However, it doesn't end there, because the recent legislation featured a new provision, which people are still trying to interpret. But one interpretation is that, well, even if your number is 0, even if you've done a vacant land analysis, you're still supposed to satisfy, I think we asked, at least 25% of what's known as unmet need. Another piece of jargon, but in any event, unmet need represents the difference between what the state number and your vacant land number. In this case, it happens to be 150 minus 0 equals 159. So you take 25% of that, of the 159, which essentially yields rounded upward number 40. So that becomes the magic number that we have to negotiate around with Fair Share Housing Center to come up with zoning and other mechanisms to try to get to that number. I'll explain how to do that in just a moment. And the chart that you see before you just gives an overview of our various obligations, beginning with the 1st and 2nd round, 3rd round, and now we're in the 4th round again. So as far as the Fair Share plan is concerned and how we address the borough's different obligations, the prior round, which is now consolidated rounds 1, 2, and 3, was satisfied with a number of mechanisms, one being senior residence at St. Peter the Apostle Church on 5th Avenue. While that facility has 23 total units or bedrooms, we were only able to utilize 18 of them because there's a senior credit cap. So in this case, because the number was 73, we couldn't exceed more than 25% of that. The borough also has 3 existing group homes, as noted on the chart, which add up to about 12 total affordable housing units. And then finally, as part of the 3rd round compliance, the borough adopted new redevelopment plans for the Newbridge Landing Station redevelopment area, which is the area that essentially straddles the Newbridge Landing train station at the south end of town, as well as the Kindercamack Road redevelopment area, which is across the street. That's again how we satisfy our prior round obligation. This is just an aerial image of that Newbridge Landing redevelopment area. And then the Kindred Mac Road redevelopment area across the street. So as far as the fourth round fair share plan and the borough's effort to address this, again, unmet need or slash redevelopment obligation of 40 units, there are a number of mechanisms, including existing credits that we're able to apply. The first being the remaining 5 units of the St. Peter senior residence. So again, 5 of the 23 can apply to the fourth round. We apply the Newbridge Crossing senior units that exist at the newer multifamily buildings between Howland and Reservoir Avenue on the east side of Kitticamack Road. That's a developed project. It's completed. It's occupied. That project contains within it 7 senior affordable housing units. The next is a new feature in the borough's housing element fair share plan, which is what's being referred to as the Johnson Avenue overlay zone. And I'll give an overview of this particular site in just a moment to orient everyone. But that site calls for an overlay zone which preserves the underlying zone, so it doesn't take anything away from the existing property owners. They can still develop in accordance with the underlying, in this case, it's the C2 commercial zone. But now we've created the opportunity where if they develop in accordance with this new overlay zone, they could produce affordable housing if they choose to develop in this manner. And that project would yield 13 affordable units. We also have what's being referred to as the North Kindercamack overlay zone, which is the other end of town, essentially where the Riverdale filling station is. Again, I'll give an overview in just a moment. And it built out that project could yield 7 affordable units. Similar case where it's an overlay zone where the underlying zoning remains in place, but it creates a second optional zoning framework where a prospective developer of the site could use that to create affordable housing where the underlying zoning currently doesn't allow residential development. We then have continuation of the Newbridge Landing Station redevelopment plan. The difference there is that in negotiating with Fair Share Housing Center, we modified the density there upward to 36 units per acre. Next to that, we have the existing affordable housing 1 overlay zone, which is an existing zoning, which exists essentially on Newbridge Road, where the BP gas station is, the golf simulator facility is, and the plant store. So that's an area that constitutes this affordable housing 1 overlay zone. Again, it's an overlay zone, so those uses can persist, they can exist. The site can be developed either with the underlying commercial zoning or again have this optional affordable housing overlay zone applied. Then we have the multifamily and senior conditional use zone. This is an existing zone. It's essentially just north of that Newbridge Crossing multifamily building. Again, that's on the east side of Kindercamack Road, just south of Howard Avenue. The only thing that we adjusted here, no changes to the dimensional criteria, to density, the building height, or anything like that. We simply updated the affordable housing set aside from 15% to 20%, which is something that municipalities, state law are requiring. And then finally, similar to that issue, the borough has what's known as a mandatory affordable housing set aside ordinance, whereby if any affordable housing, if any residential development of 5 units or more is developed in the borough, it must include affordable housing. And so while we can't capture in this plan spontaneous development, we'll call it, that's again not specifically identified, it means to say that when and if such a development would occur, they have to produce affordable housing. And again, we've upped that requirement from 15% of the total number of units to 20%. So this is a summary of our fourth round compliance chart to again address that 40 unit unmet need / redevelopment numbering. And I'll just give a brief overview of the different sites. So this is the existing St. Peter's senior residence, which is attached immediately next to the St. Peter's Church on 5th Avenue. Again, it has 23 total senior units. This is that existing Newbridge Crossing development that I mentioned, which is on the east side of Kindercamack Road, just south of Howland Avenue.
Actually south of Reservoir.
South of Reservoir here? Okay, so south of Reservoir, but in that vicinity. Again, existing. This is the new Johnson Ave overlay zone, which occurs immediately south of Route 4. So it's 5 parcels in total. I believe it's about 1.57 acres, if I'm not mistaken, and is developed with an industrial building and what had been a retail building. So again, this overlay zone creates the option that, residential development could be developed there to produce some number of affordable housing units. The next overlay zone is at the north end of town, which includes the Riverdale filling station, adjacent service parking lot and Verizon. And again, this is an overlay zone that creates the opportunity for residential development where the C1 zone currently does not allow residential development. That site in total is a little over 2 acres. This is the existing Newbridge Landing redevelopment area. Again, this is an existing redevelopment area in the borough, and the only adjustment that we made was increasing the density in accordance with the borough's settlement agreement with Fair Share Housing Center. And again, it straddles the Newbridge Landing Station with part of it owned by NJ Transit and part of it owned by the Borough of River. This is the Affordable Housing 1 Newbridge Road overlay zone. Again, this is the encompasses the BP gas station, the golf simulator facility, and immediately north of that is the plant retail store. I think it's about 2.5, 3 acres in size, but the only modification here was a slight uptick in the density, again, in accordance with settlement agreement with Fair Share Housing Center. This is that existing multifamily senior conditional use zone. It's been in place since at least 2009. It in part produced the Newbridge crossing development immediately south of that I referenced earlier. So again, this doesn't impact the existing homes that are there. It's just a zoning mechanism that if somebody were to assemble properties there, could develop in accordance with the zoning that's been in place for, again, almost 2 decades now. So that was a snapshot of the fourth round compliance mechanism. So just as far as the schedule process moving forward, hopefully it's my recommendation that the board will adopt this amended housing plan this evening, which again is the next step in the compliance process. As I mentioned, the mayor and council will introduce the implementing ordinances to create these new affordable housing overlay zones, as well as amendments to the existing zoning as I referenced. This board will then, on March 11th, conduct the management plan consistency review of those ordinances. Then finally, it's anticipated the mayor and council will adopt those ordinances on March 12th. If all goes well, we'll have met our statutory compliance deadline by March 15th. That will be then reviewed by the Mount Laurel Percentage Judge, who will then have the opportunity to grant the borough compliance certification and hopefully immunity again for the 10-year period ahead. So with that, I'll entertain any questions from the board or public.
Questions from the board?
Are there any members of the public? There is one member of the public, so if you're on Zoom and you'd like to participate in the hearing, please raise your hand on Zoom. No, doesn't look like that. And anyone in the audience? Yeah. And you can
Good evening.
just state your name and address for the record.
Paul Imperato, 52 Atkinson Street, River Edge, New Jersey. So regarding the, just to put my, it's a half acre density for, I believe you said 30 units?
Which say,
So I'm sorry, 52 Atkinson Street, so we are already in that need of redevelopment. So is that part of where you had across from Boodles or
so,
from Denala's? I'm schooling myself. Because
oh,
whatever that
yeah,
restaurant is
across,
right now.
yeah, so that new
So
overlay zone,
part where the 55 Kinnicamack, 52 Atkinson, that parcel that I own, right across from the firehouse. Is that in this?
it is to the extent that it's a plan that was adopted in the prior round. So it allows for multifamily, I want to say it's 20 units per acre, something like that. And so it's not something that's new.
this just kind of recognizes that that's something the borough adopted previously.
Right, so if I needed to increase the units, I would have to get a density, variance, obviously, right? So what would be the percentage of, affordable? Would that be, stay at the 15%, or would it go to 25%?
I have-
You,
I'd have to look at what the plan said. I think, so that plan is a little more specific because it's a redevelopment plan, so I think it's 20% is my understanding, which is sort of the state standard these days, but what I would suggest is that, well, I said, the plan is the plan, but as you're obviously the owner of that site.
Yeah.
And as you think about how you might want to develop it,
yeah,
I'd recommend that you stay in touch with the borough and,
right, so when the borough deemed it in need of redevelopment, at that time it was 15%. Was affordable housing, so my question is, does it still, through that process, does it still stay at that 15%? Because at that point it was deemed, so does that automatically change? Because I have a resolution, well, I don't know if it's a resolution, I guess it would be a resolution.
I mean,
Would that need a redevelopment at that certain point?
it was a multi-step process. So step one is you decide it's an area you need to redevelop.
Right.
It qualifies, it checks the box, and then you have a redevelopment plan, which is like the zoning framework.
Got it,
And I think the plan that was adopted was a 20%. A part of that was to satisfy the borough's prior obligation. So like, we're in the fourth round, that was for the third round. And so that's the number that's in place. Now, there are circumstances where there are all sorts of adjustments that, if for financial hardship or something like that, there may be some amount of flexibility, but the number as it stated in the plan is 20%. And as far as I'm aware, but it doesn't have to do with the change from the third round to the fourth round. I think, just to be clear, it's because that plan says 20%, and this was part of dealing with Fair Share Housing Center in the third round.
okay,
So it's not changing as a result.
Got it.
This process.
okay, thank you very much.
Anyone else in the public who should be heard on this topic?
There's no other members of the public.
Comment before? Done, I'll look for a motion to take copy minutes of the.
So moving.
And Ms. Mullin have a second. All right, Mr. Mayor,
Yes.
Mr. Coughlin,
Yes.
Mr. Craig,
Yes.
Ms. Boland. Yes. Mr. Gibbons,
Yes.
Mr. Kaniga,
Yes.
Mr. Salva,
Yes.
Mr. Gautier,
Yes.
Councilman Glass,
Yes.
and Ms. Levine.
Yes.
All right, the motion passes.
Thank you.
Thanks, Tom.
Thank you, Spence, thank you very much.
Thank you, sir.
This is Tom.
Maybe just take a 2-minute recess.
Days and staff. Now at 8 o'clock, we'll reconvene in 2 minutes. Was motion to?
So moved.
Second. All in favor?
Aye.
canceled all the flights on Monday.
Yeah, no, fine.
Canceled most of the flights yesterday morning, but we had a, took a 5 o'clock flight last night, I didn't think I was getting back.
We're down in Florida.
Yeah.
My wife got stuck, she's supposed to come on Sunday, just whatever.
Interesting.
Five lift pickups, oh, yeah, within an hour. Oh, no, it's just.
Then I came in,
Like from Newark Airport?
the boiler,
Oh, man.
the boiler was in the house, I have no heat, no. Don't even get,
Sorry, the issue getting home, I don't feel that.
the shield, there's holes in the shield.
Low level.
Yeah, why don't I make friends? Thank you very much.
Good idea. What? Oh. Huh?
Yeah, sorry. On the road, she's still there.
One of my friends goes to the bar. He'll text me, you always look on whether I'm.
I said to him, like, are you on? He says, yes. He goes, you having fun yet? I said, always.
Monday. I could have flew today. What was I gonna do in that?
This is what he wrote about Tom.
No, it's like 70 something. That was the question, the heat wave.
Gotta say, oh, no.
60s and 70s.
Reconvene the meeting of the municipal land board for River Edge is Wednesday, February 5th, time now is 8:09 p.m. We'll do a quick roll call. Craig, here, Ms. Baldwin,
Here.
Mr. Gibbons, here, Mr. Keegan, here, Mr. Salvo, here, Mr. Devian,
Here.
Ms. Lee.
Here.
Also in attendance is special counsel Weedman and planner Mr. Benz and engineer. Mr. Scott. So at this time, we are on our agenda this evening, we're going to move to hold business. Applicant is IAA2 Services LLC. And that was carried on the record during our meeting of February 11th, 2026. Subject property is 41 Grand Avenue, lot 1405, lot 4. Application is seeking preliminary plan set and approval of use site, bulk variance relief, to construct and operate a double-faced static billboard sign on a single monopole. Good evening, council.
Thank you, Mr. Chairman. As a reminder, I'm Robert Falkenson from the Law of Stevenson EC. And we've been here on several occasions and over the course of several hearings, and the record has been developed by our expert testimony, and we have concluded our testimony. We are back here tonight because I believe it's now the objectors who are going to present their witnesses, and we're ready to proceed.
Okay, thank you, sir.
I think we'll start with Mr. Sarlo, you've got two witnesses. Mr. Kenny, do you have any witnesses?
I do not.
All right, so we'll start with Mr. Sarlo. Not like the record of information, but if you just, we don't want to see your plan, so.
Good evening, Mr. Chairman, members of the board, council, Madam Secretary. Charles Sarlo on behalf of Dark Star Development LLC, who is the property owner of 335 Johnson Avenue, block 1405, map 3. Basically adjacent to the tag according to the subject property, which is the matter of this application, as well as my second client, interrelated, is Let It Grow, who also has a corporate office here in River Edge, but is also the proposed tenant for the new office building at 335 Johnson Avenue, which was approved by this board about 2 years ago, if I'm not mistaken. So with that, we did do cross-examination of the applicant's witnesses. I do have in opposition 2 witnesses this evening. I think they'll be fairly quick. One is actually the project architect that actually testified before this board as it relates to the 335 Johnson Avenue application, to just refamiliarize the board and any new members that were not part of that hearing, what my client's project is all about, and then specifically related to the rooftop amenity, which, being blunt and candidly, we fought hard to convince the board to grant that approval, because it is a trend that's happening certainly in New York City, and here in Jersey City, or here in New Jersey, but Jersey City along the waterfront, and now I'm kind of migrating to the west. I do a lot of work. I represent developers in Patterson and Passaic, and they're actually starting to do, the developers there are starting to do rooftop amenities. So it's a trend that's continuing. That's why we bought Hart, particularly because Let It Grow was going to be their office, and they're in that line of business, so they certainly wanted it almost like a showcase. So it's very important to my particular client. And then we have Mr. Peter Stepp, professional planner, who will provide planning testimony, obviously providing a counter opinion to the applicant's planner's expert testimony, which was John Scott. So with that said, if there's no questions, I'd like to call my first witness, Victor Follett.
I'll just sit over here.
Mr. Summer, it's actually that microphone too.
Yeah.
Mr. Follett, we're going to stand in and swear to.
You swear affirm the testimony about the things the truth, all truth, nothing but the truth, so help you God. I do. All right, so sworn, please state your name, spell your last name for the record, and use your business address.
Victor Folletti, last name Folletti, F-I-L-L-E-T-T-I, registered architect. And your business address? 143 Terrace Street, Harworth, New Jersey. Do you want to qualify what you said?
Mr. Follett, for the benefit of the board members, please present your qualifications both academically and professionally as it relates to the field of architecture.
I hold a bachelor's degree in architecture issued from New York Institute of Technology. I hold a registered architect license in New York, New Jersey, and Connecticut. I've been in front of many boards in Bergen County, including this one.
And Mr. Follett, you've designed office buildings in the past?
Yes, I have.
Okay, and were you the project architect for 335 Johnson Avenue?
Yes, I
And
was.
specified before this board in connection with that particular mission?
I did.
And the exhibits that you're going to show this board this evening, were they prepared by yourself or under your direction?
Yes, they were.
Okay, I'd like to submit Mr. Follett as an expert in the field of architecture.
Any questions, Mr. Johnson?
The world.
Okay, good evening. So, the board that I have presented here, I was hired by the owner to prepare a representation of what the proposed, double face sign would look like, from the rooftop amenity plan that we had proposed for his building. That,
Even before you start, and mark this as O-1, if you could just say what the date of it is and it's on the title block.
sure.
No, you would, if you actually just bring the stand a little bit closer to us. Right here's good. Perfect.
So the title of the drawing is Proposed Study for Neighbor Sign, Dark Star Development LLC, 335 Johnson Avenue. It's dated September 23rd, 2025. This drawing was created with the site plan and the engineered information that was provided to us by the neighbor. It is a scaled, accurate size of the proposed sign, and it is orientated and laid out similar to the sign that is being proposed here. The wall that you see here is the parapet wall for my client's building. This is what it would look like from the rooftop amenity space that he had proposed, looking to the west. The sun configuration, casting shadow and This direction is accurate. That is a depiction of the proper north orientation and where the sun would come from. And the relative height of the sign to the parapet wall is also accurate. The bulkhead that you see here is the bulkhead of the neighboring building, and it shows an accurate height, location for the building next door relative to the sign. The sign is about 48 feet long, 17 feet high, 20 feet in its widest dimension. It is 43 feet to the bottom of the sign. After being several hearings here in the last couple of months, counting tiles and looking at this space, the sign is approximately the length of this room. And the width is about the width of this dais, and the height is about the height of this room. It is, the bottom of the sign is about a foot in elevation above the parapet wall. Our parapet wall is 4 feet high at elevation 38. The distance of the sign to our building is approximately 32 feet. It's 17.8 feet to the property line, and we are 15 foot 3 inches setback from the property line to our proposed building.
Can you have dimension again?
The dimension from the sign to the building is 32 feet. From the sign to the property line is 17.8 feet.
And from and then what the last,
So our building is set back 15 feet 3 inches from the property line.
15 feet, 3 inches?
Correct. Second drawing is a elevation drawing showing the sign with the building next door, the height of the sign above that building next door, and how that sign would be relative to our building.
We'll mark this as a tip.
Yeah, so to, read the title of the date.
Sure. Title block is labeled elevations. The date is also September 23rd, 2025. There are two elevations. There's an east elevation. That's the front of our building and front of the neighbor's building as we approach. The north elevation is the side of our building with the sign in the foreground. Again, showing the elevation and the height relative to our building.
This one, exhibit 03, something to be.
This drawing is labeled site plan. It has a date of January 12th, 2023. This was the site plan for our proposed building. That's why the date is so old. And I superimposed the proposed sign onto that drawing. And it has the dimensions that I just went over, 32 feet to the building, 17.8 feet to the property line.
The rest of the drawings are the drawings that we presented when we proposed in the building. So we read the installments and get to show us.
So this drawing was used for the presentation of the new building. It's dated January 19th, 2023. It's labeled Perspective Rendering A2.
That will be marked exhibit O-4.
This is what we would call the rear of our building facing the parking lot. This was presented when we were obtaining approval for the building. It does not show the proposed sign. The other fact, I do want you to mark each of these, yeah, that's what.
Oh, sure.
So we know exactly what.
This one is gonna go forward.
Or yes, put today's date on it.
Sure, and I'm gonna ask you to leave that exhibit for. And Mr. Charles, if you can send electronic copies, whatever you should.
So he's gonna leave that, we're gonna have to take that. Keep that, but
Leave this one open.
While you're doing
Does
it,
that.
yeah, back up.
I don't think they sent them. Cause they're the objector. So they're- it's done.
The next drawing is the front rendering of our proposed building. And prepared at the time of the, filing for the new building, but not depict the, proposed sign.
We mark that as, 05.
That's,
And that's also dated January 19th, 2021.
yes. This is a plan prepared by MPFP. They were the consultant for the rooftop amenities, showing furniture, plantings, some trellises. This was the plan that we presented to show the board how the rooftop was going to be used. It was not prepared by myself, but it was used as part of our presentation.
And Mr. Sarlo, that's what was approved by the board.
Yes.
Mr. Clay, could you provide some more testimony with regard to some specifics?
On this drawing?
Yes.
Okay. So on the drawing, there are wood decks that are rendered onto the plan. So the lawn areas or lounge areas here, raised planters with trees, tables for some of the employees to use on break. Also, wood deck lounge areas. This was supposed to be places for them to entertain clients and show off some of the work that they actually do. Samples of materials would be used throughout the rooftop amenity space to show the clients, again, the product that they provide. There was an outdoor kitchen area here, covered by a pergola and some trellis work on 2 locations, a seating area here, and planted trees throughout. Some of the work that is a specialty of Let It Grow and work that they do often.
Just move what's in.
Sure.
Okay, and then Mr. Coletti, where, can you point out what corner of this rooftop the billboard would be?
This corner right here.
And what is, I know you went through the floor, the rooftop layout, but what would be in that corner immediately in that corner?
Tables with umbrellas right here. And a raised planted with trees.
Can you just jump, orient where north is?
Okay, so this one. Okay, the right. On this drawing, north is here. South comes in just like this. The billboard is almost due north from this corner, right south. No, due south.
Due south.
Due south. We have north, south.
No, you're backwards.
I'm sorry.
You're 180.
Oh, I'm sorry. It's not my label here. Again, south is here, north is here.
So the billboard's on,
The billboard is on the south side. Yep.
okay.
Yes, sorry about that.
Still with the seat, still with the seating area with the tables and the umbrella for eating Correct.
Right here, yes.
And, would that also be, Mr. Fletty, did your client tell you that would also be used by the occupants of the building for, lunch areas and gatherings after work?
Yes, he did. This would be for gathering areas for the employees on break, and again, after hours, to be used by the employees.
And you've also mentioned to bring clients up there possibly during the lunch hour.
Yes, that is, when the design was being laid out, it was that the materials that Let It Grow uses and installs would be on this rooftop amenity plan, so that clients could actually see some of the product that they provide.
And, Mr. Fletty, from an architectural standpoint, from an architectural opinion, would the proposed billboard have a substantial detriment to the impact of proposed building at 335 Johnson Avenue, and specifically as it relates to the rooftop? And
I think, this drawing is the one that I used to illustrate that fact. Again, it would be blocking the sun, casting a shadow onto that building. And, I mean, you see it, that's the impact that it would have on that space.
so is it your opinion, testimony, air and light
Correct.
impact,
It would impact air and light. It would impact light significantly. That's it.
aesthetics?
Aesthetics, unless you like the side, the back side of a billboard and you find that aesthetically pleasing, it would be negatively impacted.
I have no further questions at this time.
Thank you. That's up to you with questions. Just for the record, you're not a licensed professional planner, correct?
I am not.
You're not a licensed professional, you're not a professional engineer, anyone?
I am not a professional
And
engineer.
you're not a traffic engineer.
I am not a traffic engineer.
You didn't conduct a traffic study at the site?
I did not.
Did you conduct a glare study?
I did not.
You conduct a shadow study?
Yes, I did. Preparing the rendering, I illustrated the shadows that are being cast from that building. It is an accurate depiction of the shadow lines as they come into the property for this location.
Is there any sort of scientific report that goes with your picture?
There is not.
And how did the shadows get generated?
Through the rendering software that we use to generate the drawing.
And what's that software?
It's called Enscape, is the software that we use for our renderings.
And you put in all the coordinates and renders the shadows for you?
Yes, it does.
And are you a surveyor?
I am not.
And so you did not perform a survey here?
I did not.
So you utilized somebody else's survey to pinpoint the locations?
I did. I used the engineering drawing that was provided, to my client from the neighbor.
So there is no scientific, there's no measurements of, we're just looking at a picture that depicts shadows?
This drawing does not have any measurements. It's just a rendering.
And there's no scale to it?
There is. This is a scaled representation of both the building and the sign in size, dimension, and location.
And is there a scale on the drawing? I can't see it.
There is no scale for renderings. There is no scale for perspective. It is 1-to-1.
So we don't know how far the billboard is from where the front of the picture is, it's just, there's no measurements whatsoever.
So there is no dimension on this drawing from that billboard to the front of this picture, no.
So how would somebody, contest the accuracy of this picture?
That this is, in my testimony, when we set up our rendering, we located our point on the rooftop of the proposed building as it was designed.
And which point was it on the building?
Plan is probably right here.
But there's no way to tell from the first drawing where that location is?
only that it shows you, a rendered view of that point in location in a three-dimensional model, looking at the proposed sign.
And that was done via the computer.
And myself, and my inputs.
And there's no other drawings depicting shadows anywhere? It's simply just, one, or is that?
That is correct. There's no other drawing in shadow.
And that you submitted no report?
I have not.
And the first time the board is seeing this is tonight?
I am unaware they've seen this before. They have not.
Did you do any sort of structural analysis of the billboard?
I did not. Only in its dimensions.
Does the billboard in any way encroach upon your client's property?
It does not.
Would the billboard stop the construction of your client's property?
It will not.
And is your client's property currently built?
No, it is not. This building is not built.
And the plans that are depicted here is precisely what will be built there?
That is correct.
There's been no deviation whatsoever.
There has not.
Has the building plans been submitted?
They've been submitted to the board for the variance approval.
Now, is your client's concern chiefly that this is gonna block his view?
Objection only answer if you could. You don't have to read,
Yeah.
you don't have to read your client's mind.
Yeah. I don't know what else.
What, from an architectural perspective, is the view the main concern of the rooftop amenities?
It's a main concern. There are other concerns. Light is another concern, I would say. It's not the only
You
concern.
didn't perform any lights, so.
Only in that rendering showing the accurate shadow that would be cast by the building.
And what would be the light concern?
That the sunlight would not be able to reach the rooftop amenity space.
Was there any proposed lighting on that roof?
Yes, there is.
And was that, do you know if that approval saw any variances?
The approval of that building did seek the variance, yes.
And now. Now, would there be any, do you know if there's any access restrictions with the billboard close to your client's property?
It would not.
And it wouldn't cause any, issues with the construction of the building that's yet to be built?
It would not.
And could the roof be altered at the billboard to change the view, or the view can only be in one direction? Well, let me rephrase that, is the billboard blocking the view in all directions?
It is not.
So the chief concern is the view off the roof.
Chief concern of who?
Of your testimony tonight.
There's no concern of my testimony. I'm testifying to the facts of what impact this would have on the building, the negative impacts and how it would affect my client and the occupants of his building. That's up to them.
From an architectural standpoint, what would be the impact of the billboard?
It would restrict views, it would restrict sunlight, and it would restrict air from the south direction.
And have you identified any safety concerns?
I have not.
Okay, no further questions.
Any other attorneys have questions or members of the public have questions?
I do a few follow-up. Thank you. Mr. Bloody, once or twice you just referenced in your direction on cross the neighbor, just for clarity on the record, is the neighbor the applicant's property?
Yes.
In terms of your input into the software, you were asked whether or not you performed the survey. Is it permissible under the architectural licensing regulations to use a licensed surveyor's survey on your plans, even if you develop a site plan?
Yes, we are legally allowed to rely upon the accuracy of those surveys.
And that's what you did here?
That is correct.
And to your knowledge, your client's project is fully approved by the zoning board?
Yes, it is.
And again,
what you, especially what was marked as exhibit O-1. Based on your data input and the software that you use, do you testify that this is an accurate depiction of what this billboard would look like from the rooftop, if built?
Yes, it is.
Thank you, no further questions. That's it for the board.
I have a question, but it's actually for you.
Hopefully I can help.
Okay, well, you asked if they've done shadow studies. Has your client done shadow studies then?
No.
Councilman Burns?
You want to go first?
I think Mr. Folletti was pretty thorough, so my questions pertain to the dimensional aspects, the sun, et cetera, so I don't have any further questions.
Mr. Chairman, through the chair, thank you. Good evening.
Good evening.
Beautiful rendering.
Thank you.
So as far as the shadow study, it changes every day, right?
And every minute.
Every minute, every day,
Yes.
because I get sad on June 21st for the 22nd. You know why? We lose roughly a minute a day of sunlight. And then I get happy on December 21st, because then we start gaining. So basically, that structure is to the south. That structure is requesting from this board a height variance, which I said at the last meeting, to keep it practical. You're an architect. I believe it's in excess of 60 feet. So roughly, probably a 6-story building,
Correct.
right? You said it was the size of this room, I think, under your testimony. Basically from the front wall to the rear wall in this building, and roughly, I think you said the width of the dais.
Days, correct.
But what you forgot to say, you gotta times that by 2. Because there's 2 of them, right? There's not 1, there's 2. With that, so you're gonna see, basically, this structure is gonna cast. Then I think it was questioned or in cross the lighting. They have lighting at night because it's a static billboard. And they submitted a light plan originally, then they redid the lighting plan. But yet miraculously, that spillage stops almost at the billboard, which is kind of hard to imagine that it does that. So there's probably at night, this billboard would have some impact on your client as well when it's in the evening hours, I would think. And I think the attorney actually asked that question. Did you do any glare studies? Obviously you didn't, but under your professional opinion, would that have any effect on the adjacent neighbor within 30 feet?
Yes, within 30 feet, there could be some reflective light that's coming off of that billboard.
Could be, right? So that could further impact their adjacent property. And then the survey came up, which I brought up at the last meeting. Whether or not it was accurate, and then the attorney actually authored a letter to myself saying that I already said it was accurate. But in any review letter that engineers do, we always put a catch-all to say, could be subject to change under new circumstances, which it did. And getting back to the accuracy of the adjacent survey, I responded, I sent the letter to everybody to the board, I copied, to the attorney, Mr. Liebman. And I never got a response back from the applicant, whether I was correct or incorrect. Your surveyor's not here tonight, your engineer's not here. You didn't respond. Was I correct or incorrect? Because I think it's a material issue in front of this board. Whether the jurisdiction, if I am correct or incorrect.
We were looking into it and we didn't have a definite answer, but we would certainly, as a condition of approval, revise, and because it's related to the frontage, it would in no way affect any of the variances we're seeking. We believe that it would, it's basically how much frontage sits on Route 4. It's not the actual lot lines. It would have no impact on the proposed billboard.
Well, I think there was testimony saying that you had a license, or not a license, you had a permit from the state of New Jersey and you have frontage on there.
Yeah,
That was one. The second one that we answered
that
was,
was accurate.
how do you actually, it's not a TV set, because it's static, so people have to come and go and possibly put new signs. It's not gonna be one sign to go up unless I put a picture of myself there and say, I want this in perpetuity. And my trust would continue paying for this in perpetuity. But cars have to get in, you have to change it. And there's no clearance underneath that building.
We did present, I don't believe you were present at the meeting, testimony.
We had transcripts.
And yeah, and we did, we believe the record fully supports the fact that the site can be accessed and the billboard can be.
It's
changed.
7'6". So what we've asked, how do they do it? What do they come in? What trucks? How do they do it?
We did have testimony to that. They come in the standard size, like small SUV. It's, I mean, I don't want to restate the records. I don't have the transcript in front of me, but we absolutely did present testimony.
Okay.
And I will note, you were not here, but, you know, if you review the record, I do believe it will answer your question.
Okay. So just, again, and I think Vice Chairman Cray asked the question. So you never did a shadow study to see the effects of the height variance that you're requesting on the adjacent properties. I just want to make it crystal clear for the record. You have not done that, correct?
We have put in all our evidence. We don't have any further evidence
Okay,
at this time.
That's not what I asked.
We did not perform.
He's answered.
Okay, very good. And as far as you submitted voluminous stuff for Dr. Atkins. That I was
believe we
incorrect, and maybe I was
One
incorrect,
article.
but my recollection is I knew he went down on the sidewalk. But where did the ice come from?
The article appears that he slipped on a piece of ice on the ground. Whether, I can't speculate to where the ice came from.
Okay. Is that,
With all due respect, this is.
no, it's not, excuse me, with all due respect, it is not. Because the George Washington Bridge has closed in the past because of ice falling off of it. This is a structure very close to the front property line, Mr. Liebman. And I'm saying is, it could affect the health, safety, and welfare of the public if ice comes off of there.
That's not, what is ridiculous is to talk about whether somebody in New York City who died from a falling icicle or not. I mean, we all know
What I'm
falling
saying is,
icicles are dangerous.
I'm not talking about his specific case and what happened to that gentleman. What I'm saying is ice, and we do have ice storms in the Northeast. That has happened before. This structure, they're requesting a front yard setback on a piece of property. And my question to that, and the only reason I brought it up was, what precautions would you take in an event like that? Because certainly being that close to the property line, being that close to the sidewalk, where the pedestrians walk within proximity to a pedestrian overpass, going back and forth from Hackensack, New Jersey to River Edge, which the DOT just closed recently and created a stir last week. That's why I brought it up, sir.
Okay, that makes sense. You know, who, doctor, or whatever, they would still buy.
Atkins.
That's all.
I mean, I just wish these questions would have been presented with our experts in here. I don't have an answer.
Very good. Thank you.
Thank you, Chairman. I have one more witness, that would be Mr. Peter Check, licensed professional planner.
You swear affirm testimony about the institution, all can tell me what you yourself now.
I do.
I so for you say your name, spell your last name for the record, and use your business.
My name is Peter Steck, S-T-E-C-K. My address is 80 Maplewood Avenue, Maplewood, New Jersey.
Mr. Steck, I'd like to have you qualified as an expert in the field of professional planning, for his benefit of the board members. Can you please put your academic and professional credentials on the record?
Yes, by way of education, I have a bachelor's degree in civil engineering and a master's in city and regional planning from Rutgers. In terms of work experience, I worked in the past with two consulting firms, Malcolm Gassler Associates and Alvin Gershon Associates. I was the planning director for the township of Montclair for just short of 10 years. For the last 20 years, I've been self-employed as a community planning consultant. I've appeared in probably 250 municipalities in New Jersey and been accepted as an expert planning witness. My license was received as a planner in 1976, and it's still in effect this evening. And in the past, I have appeared in River Edge, but it was a number of years ago.
All right, Mr. Scheck.
As a fellow Rutgers engineer, I'm not going to call.
To submit Mr. Scheck as an expert in the field of professional planning.
Yes.
Okay, Mr. Scheck.
Yes, I have a handout that may be helpful to the board. May have enough.
So, Mr. Scheck, let's get this marked while the handout is being circulated. This is what you're handing out to the board members is a 8.5 by 11 stapled document that has from to 5 pages.
Correct.
And it says it's prepared February 25th, 2026 by Steve P for that's one. And is this what do you want you to try?
Yeah, I'll just briefly describe the pages and then I'll refer to them when I run through it. So the first page is a satellite photograph where I've superimposed in yellow the outline of the subject property with a label that says proposed billboards. And I show the zoning districts that are in this portion of the view. The second page has photos. The upper photo, they were taken by me on September 23rd of 2025, and I believe they accurately depict existing conditions. The one on the top of the second page is taken from the overpass, the pedestrian overpass, and it shows the approximate location of the proposed 2 billboards. The lower picture is from a pedestrian point of view, someone walking along Route 4 toward the subject property. Third page has views of the subject property from the 3 closest residential uses. So on the upper section, I have a aerial photograph with numbers 1, 2, 3. And so number 1 is where across from Route 4 is the closest residential unit. And that's what it looks like. Photo 1 on the lower left-hand side. Photo 2 is in front of the garden apartments that are in Hackensack. And that's the middle lower photo. And photo 3 is from the garden apartments that are on a little bit of a rise. And again, in all of these photos, the residents will be able to see the proposed billboard. The next page, P4, simply illustrates my client's building, and I superimpose the proposed billboard that in red on the lower left-hand side. So you see the relationship of the proposed billboard with an approximation of the rooftop amenities that were described by the attorney, excuse me, by the applicant's architect. And the last page has a larger view of the area from the Bergen County Planning Department. And here I not only show the conventional zones but I've shown, the redevelopment areas. And I'll talk about that, in a moment. The reason I'm showing them is that the applicant's planner, I'm gonna get, excuse me, I have something to drink. It's not alcoholic. I'll go into more detail, but one of the justifications of Mr. McDonough, the applicant's planner, was that this is not near residential use. And, while in one of the exhibits I show the existing residential uses, this diagram shows the potential future residential uses. So, for example, to the southeast along Route 4, as you're maybe more familiar with because of what you did this evening, there's the Kinderkamak redevelopment area with 20 units per acre. This also has the AH2 area at 40 units per acre. And there's a corner of the rezoning by the train station. So, for example, in the Kinderkamak redevelopment area, that allows a building of 4 stories and 55 feet. So if that's constructed, they'll, in my opinion, be able to read this billboard pretty easily because it's aimed at them. So let me go into the body of my testimony.
I'd just like to have this marked as exhibit O-7. In the record.
So I was here during the prior hearings. And I did review the application materials, and I was here earlier this evening to hear the testimony of our architect. This property is, as you know, an L-shaped property that has a number of non-conforming dimensions. It has a non-conforming depth. It has slightly excessive building coverage. It has a violation of the front setback. It has a violation of the rear setback, and it has a violation of the buffer required. So there's a lot that's already going on in this building. One could look at it and say it's slightly overdeveloped as it is now. The applicant has described the billboard, and while DOT may consider this one billboard, as I read your ordinance, it's 2 billboards because it's not, you don't have a front and back to it. It's a V shape. And so in a sense, it has a volume to it. So, for example, someone walking toward this building, and I'll draw your attention to, let's say, on page 2, the lower photograph, when you're walking toward the building, because this billboard is going to be on top of the building in part, it's going to look like almost an extension of the building, because you're looking up toward it. And while the billboard is going to be whatever, 7-9 feet over the rooftop of the office building, because you're looking up at an angle, it's going to add to the mass of the building. You're not going to be able to see underneath it as you're walking toward the building. So the applicant is proposing, in my opinion, 2 buildings, and as I understand it, it's a height of 60 feet. And the reason, and this, as you know, exceeds the height that's permitted of the proposed height is 60 feet, whereas the maximum height in this zone is 35 feet. And, while the applicant, wants to garner as much view as possible, in my opinion, the real reason for the height is that they don't have enough room on the property to put a billboard, except that they have to now cantilever it over the building. If this lot were larger, if it were underdeveloped, if there were more space around it, you could have a classic billboard that wouldn't have to be 60 feet tall to the top. But the reason it has this height is because the site's already overbuilt. And the applicant is now putting a second principal use on the property. And because there's not enough room, and keep in mind, they're violating the front and the side yard setbacks. This is a height that is driven by the fact that there's already full development on the subject property. And if you recall, the variances, well, before I go to that, this is in a commercial corridor. It's a state highway. The applicant's planner did not talk about the search of other properties in the area that might have been equally suited or more suited. Mr. McDonough simply said, it's along Route 4, so it's a great place for a billboard. And he says that it, met the state standards, at least for a permit. But this is an area which right now does have some residential uses. It doesn't have buildings that are 60 feet tall. If you, as I did, stand on top of the pedestrian overpass, there's no building in River Edge that has a height anything close to 60 feet in height. And again, there are a few residential uses in the area, contrary to what I believe Mr. McDonough said. But your plan is to have more residential uses in the area, in the redevelopment area. And Mr. McDonough simply did not reference that issue. I looked at your master plan, which is dated 1984, as well as the two re-examination reports that follow 2009 and 2020. And, clearly the municipality wants a healthy commercial area in this corridor, but it is concerned about aesthetics. The character of the commercial area is important to the municipality. That was true back in 1984 when the master plan was done, and that goal has been repeated as recently as 2020. Now, this is in a commercial zone, and as you saw on the first page of my exhibit, it's a C2 zone, and while billboards are not permitted in any zone, it is conceded that that you can't prohibit them automatically, and the applicant is seeking a D1 variance. Mr. McDonough admitted that this is not inherently a beneficial use. This is a commercial use. And because it's a use that's not permitted, it's subject to the standards of the Medici case, where you have to show that there's some public purposes that are advanced, looking at the purposes of the land use law. And this is key, you have to show particular suitability. That's not that it's the only site in the whole municipality, but there are characteristics of this site that lend themselves specifically for a billboard use. In fact, a billboard that's cantilevered over a building. And also the applicant has to meet the negative criteria under the enhanced burden of proof. So just to recall, the variances that are needed is that this is a use that's not permitted, so that's a D1 variance. And that's why this board is jurisdiction, and that's why it's a Medici case, in theory, the hardest, variance to secure. There is also the issue of a second, principal, use on the property. That's also a D variance. Not the high standard of Medici, but it's still a D variance that again triggers this board, and 5 affirmative votes. The applicant is inching up, this is already overbuilt in terms of impervious coverage. The maximum is 80%, and the applicant is going from 95.4 to 95.55. So it's already overbuilt, and now the applicant is adding more impervious coverage. It violates the front yard setback significantly. The requirement is 30 feet, and the applicant is doing 10.78. There's a side yard of 15 feet, and the applicant is doing 10. And there is also a rear setback of 20 feet, and the applicant is doing 17.86. So this property is already overdeveloped, and the applicant is seeking not only a use variance, but a height variance. And again, in my opinion, the reason for the height variance and all the setbacks is there's not enough room on the property. First of all, your ordinance says one, principal use per property. But aside from that, there's not enough room, and that's what's triggering this height of 60 feet, because they don't have enough room to place this, even violating the setbacks, they don't have enough room to put this, these 2 billboards on a pylon, and have to cantilever over the top of the building. Now, I know the board, was present and heard the testimony of Mr. McDonough, and I just want to, it is what it is, it's on the record, but I want to make certain comments about what he testified. He said it, DOT considers this one sign, and I don't doubt his testimony, but the answer is your ordinance, in my opinion, considers this 2 signs, and there's an impact of that. This is not a single board with a front and a back. This is a V-shaped, so looking at different directions, it has a volume to it that wouldn't normally be there. Mr. McDonough relied a lot on the state statute for billboards, for the state DOT issuing permits. That's not a special reason. That might be part of the negative criteria, but because someone has a permit from the state doesn't mean that it automatically meets the negative criteria in terms of your ordinance and your variances. There is no evidence on the record that an evaluation of this whole Route 4 corridor. Mr. McDonough simply generically said, this part of the municipality has a state highway, that's where it should be. But he didn't analyze any portions of this that might be better suited or equally suited. He kind of generically said, this billboard ought to be along Route 4. There may be other properties that are not overbuilt. There may be properties that don't have buildings as tall, and consequently a billboard doesn't have to be as tall if it's cantilevered. He admitted that it is not an inherently beneficial use, and I concur with that. He cited 3 purposes of the municipal land use law. Purpose G, H, and M. G talks, and I'm just going to paraphrase it from the municipal land use law purposes. G talks about providing sufficient space in an appropriate location. There's not sufficient space. He's violating the setbacks. He's violating the height. He has to cantilever over the building. That means there's not enough space on the property. So I don't know how you promote purpose G. He talks about purpose H as promoting the free flow of traffic. How does a billboard help the free flow of traffic? When you really, in citing that it met the distance requirements of DOT, that might be looked at as a negative criteria issue, but it clearly doesn't promote the free flow of traffic to have a billboard. And then M talks about more efficient use of land. And my comment is, where do you stop? This site is already overdeveloped. Putting a billboard now violates the front and side setbacks. It increases the impervious coverage on a site that's already overly paved. Just encouraging more efficient land, I think you have to take into account, is this overcrowded? Is this lot already overbuilt? Like it says, we don't have to take down any trees, but I think the review memo said that the applicant already took down some trees that were in the area. He referenced goal 8 of the master plan, that said there's a need for diversity. That's kind of in different kinds of land uses. And I'll grant you, there's, there are not many billboards in town now, and just adds a billboard, but in my opinion, that is, why not a state prison? That would add to the, just saying that this responds to the goal of diversity, in my opinion, does not advance that purpose of the master plan. So, the applicant, as you know, has the burden of proof. And in my opinion, the applicant has not met that burden. This has nothing to do with freedom of speech. I understand that it's a billboard there, you can't control the content or the timing, but this is a set of 2 billboards that has essentially a volume to it when you look at it from different directions. From certain points of view, it's going to look like it's attached to the building as you're approaching it, walking up to it. It is the tallest structure in the area in River Edge. And it will be seen from a great distance. And it will be seen from at least 3 existing residential uses, but equally important, there are planned through redevelopment efforts, new housing developments, and the Kinderkmack redevelopment area allows buildings of 55 feet in height. So if someone builds according to the ordinance, they're going to be aimed at one of these billboards. So that's contrary to what Mr. McDonough talked about. The master plan not only wanted a viable commercial area, but it concerned about aesthetics. That was true from the first master plan, and that was reaffirmed in the 2 subsequent reexamination reports. So in my opinion, there are no municipal land use law purposes that are advanced, at least as described by Mr. McDonough. I would say that this site is particularly unsuited because it's already overbuilt, as evidenced by the statistics of impervious coverage, setbacks, dimensions of the lot. The applicant is asking for a second principal use and one that has to be gerrymandered around the building. Why is there 60 feet in height? Because there's no room to do a billboard 50 feet in height. That's why it's that high, because it's an overcrowded site. So in my opinion, there are no municipal land use law purposes that are advanced as presented by the applicant's planner. This site is particularly unsuited for a billboard. It's already overdeveloped. It's overcrowded. And the fact that it's cantilevered adds to the height, which would not necessarily be the case in another site. And in my opinion, if this is granted, it will result in substantial impairment, substantial detriment to the public good, and that it will be the tallest structure in the area, and again, it has a volume to it because it's a V shape. It will adversely affect my client's building with the rooftop amenity. And southwest of his rooftop is what we call the New York City skyline. That's one of the reasons why he invested in plans and is proposed to build that, because this is going to block part of the New York City skyline. Aside from being, it's maybe a technical word, ugly from the back. You know, you're going to see the back of this billboard, and that's and in my opinion, it is offensive even on the front because it produces reflective light, but it's also offensive because it's a bare structure in the back. And because of the importance in the master plan for aesthetics in terms of your commercial district, in my opinion, granting this would result in substantial impairment of the master plan.
Thank you, Mr. Scheck. I just have two quick follow-up questions. So do you agree that the New Jersey Supreme Court price standard is for a use variance is the general welfare is served because the site is particularly suited?
Yes, that's the standard that started out in the Medici decision.
And you went through Mr. McDonough's testimony as it relates to the three purposes of municipal land use, purpose of municipal land use law that he testified to.
Correct.
And are any of those purposes that that he testified to that you reiterated deal with promoting the general welfare?
They do not, in my opinion.
And isn't it true that a very specific purpose of the municipal land use law, which may be subparagraph A, specifically is, said, the purpose to promote the general welfare, safety, etc.
Purpose A talks about encouraging most appropriate use of land to advance the public welfare. Purpose I talks about aesthetics. Those two purposes are clearly not advanced by this application.
In your opinion, in reviewing Mr. McDonough's testimony, did he support the promotion of general welfare in any of these?
I don't recall that. He said that it, promotes a business use, and he commented, they might have an advertisement for like a church or a hospital, but that, in my opinion, is an incidental benefit. This, just having a billboard, a commercial use, does not by itself, in my opinion, advance the general welfare.
Thank you, Mr. Scheck.
Sure. You want to let the attorney ask first?
Whatever, it's up to the chairman.
I'll ask.
Okay.
Yeah, I'll give you. Mr. Steck, thank you for your testimony. Pretty thorough. Just a couple follow-up questions for you in no particular order. So I may come back to this issue a couple times. So the issue of site suitability pertains to two things from my perspective, both the site suitability with respect to the context of the site within the community, but also the specific attributes of the site. Is that accurate?
Well, the focus, in my opinion, is on the characteristics of the site itself.
Fair enough. So if we focus on that issue alone, I think you raised that there were a number of variances required. So from your perspective, there are applications that sometimes could just require use variance, but they meet all the other criteria. From your perspective, because they're requesting a number of variances, does that impact the site suitability aspect of this
In
case?
my opinion, it does very much. Again, if there were enough room to have a billboard and not this height and would meet the setbacks, in my opinion, it would potentially be a better case from the applicant, but I think this all works together. The fact that not only is the use not permitted, but the fact that there are so many items of dimensional relief, and they are not minimal, they're significant dimensional setback issues. In my opinion, that composite means to me that this site is not particularly suited.
All right, thank you. And you alluded to it, but based on the applicant's planner's testimony, his justification seemed to be summed up as just being proximate to a highway is sufficient enough. From your perspective, is proximity to a highway enough to justify?
It is not, in my opinion. He did say that, you know, this is a state highway, most of the houses are to the north, but he was unaware that there's new housing proposed. He didn't identify the 3 views for residential units that I did. So in my opinion, just because it's on a state highway, does not satisfy the statutory criteria.
Thank you. So to that point, based on your exhibit, I'm on page 5 right now. So you referenced the number of housing developments that are in, essentially surrounding the development. In how many directions are there existing and proposed residential developments around the building?
Well, if you'll look at the composite, if you look at page 3 of my exhibit, which was 07, you'll see that across Route 4, there's a garden apartment development plus one residential building. That residential building is the closest view. Behind the liquor store, number 3, that's up higher. And so that clearly will have a view of the billboard. And then, so those are existing situations. And again, if you look at the 5th page of my exhibit, the municipality is promoting fairly intensive housing eastbound on Route 4. And particularly the Kindercomack redevelopment area, that is opposite one of the faces of the billboard. And since that zone allows 4-story buildings, I think in 55 feet in height, those upper units are going to be looking right at this billboard.
Right there. And just for the record, as far as cardinal directions though, like where is the residential development and existing and proposed relative to the billboard?
Well, the R1 zone and the R is single family and I'm looking at page 5. Yeah.
Right. Yep.
The R1 and R3 zones are to the northwest. To the southwest is the closest residential building, which is at the foot of the pedestrian overpass. And to the southeast are the redevelopment areas and areas proposed for affordable housing.
All right, thank you. And looking at that same exhibit, you'll note let's say the right side of the page, which is to the east, is the borough's Newbridge Landing Station redevelopment plan. Are you aware it's called that because there is in fact an NJ Transit train station right there?
I think that's why they use the word station.
Yes, right. How close is that to the proposed billboard?
I would say.
In terms of blocks, not.
Well, I'd say it's probably about 1,000 feet.
About 1,000 feet. So
Okay, and let me think, it's about 1,000 feet away.
would you consider the area around that train station to be transit oriented?
Yes,
Does the transit oriented nature of this commercial area of River Edge make it unique along other areas of Route 4?
well, it's a strong state policy to promote development by the train stations, and that has I think a density of 36 units an acre. So there is a recognition that that's an area that is proposed for new growth and including residential uses.
To that question, though, are you aware of any other similar transit-oriented areas along Route 4 that have, let's say, proximity of, 2 or 3 blocks to a train station?
I don't recall any, but that was beyond the scope of my research.
Fair enough. Just going through my list here. I think you mentioned that, well, I guess I'll ask you, is your understanding that aesthetics are considered a compelling governmental interest?
Well, it's a purpose of the municipal land use law, and it's not just, the color of the building. It has to do with the bulk. And again, this is a V shape, it's 2 billboards. In my opinion, it will appear to have a volume to it. And it will be the tallest structure in this part of the municipality existing now. That's significant. And again, while it's aimed to look at eastbound and westbound traffic on Route 4, by virtue of the fact that it's sticking up in the area more than any other building in River Edge, it draws attention.
All right, so the applicant's planner alluded to the idea that all of the C variances being requested are essentially subsumed under the D1 variance. And I know in some cases that is accurate where, you know, the nature of the use variance being requested requires that all the C, you know, the aspects, you know, the bulk issues to be required. Is your understanding that these C variances being requested are a function of the billboard? In terms of setback, in terms of height,
Well,
et cetera?
In my opinion, first of all, when it's subsumed, it doesn't mean that they disappear. They're still relevant when you violate the dimensional requirements. And again, if, you know, my client has a vacant piece of property, if he had the billboard, you know, you could comply with probably all of the dimension requirements. It would be the only use of the property, it would meet the proper setbacks, except you probably couldn't see it. But in my opinion, the magnitude and number of dimensional deficiencies go hand in hand with the fact that this site is not particularly suited for this use.
Right. So in other words, would you agree that they're not necessarily subsumed then, the C variances?
Subsume means that because a billboard wasn't a permitted use when the dimensional standards were drafted, they weren't thinking, you know, billboards. But the answer is, because this is, it's kind of a structure that's in your face. All the improvements are supposed to be back behind the front yard setback. This is like 1/3 of the setback. It's right by the sidewalk. It's more intrusive than any other structure in the area.
Right, and if it wasn't developed with a 3-story building and had adequate space, in theory, it could meet
It could.
More of the
it could
criteria.
use- It could
Right.
potentially, well, then the applicant could probably comply with the 35-foot height limit, so it could comply with all the dimensional standards except for the use.
Okay, and so for a minute, if we entertain the idea that the applicant would have to address both the C1 and C2 criteria from that perspective, I mean, as a planner, could you address whether or not, I think they represented that this was a public benefits.
Well, there's no hardship here because the property's already developed.
Right.
And and in fact, it is overdeveloped. And the fact that there are such, there's a magnitude of setback, there's a number and size of setback variances, only tell me that, again, this is particularly unsuited.
My final question would just be, if this application were not to be approved, would that render the site into inutility?
No, there's already a building on the property and the property is already overdeveloped.
Okay, and is the office building that exists on the property a permitted use?
Yes, it is.
Okay, thank you very much.
Just, one or two questions. I'm sorry. So, Mr. Steck, you said this a few times tonight, unsuitable. When you looked at the site, because I asked this question, I don't think I got an answer back on it. What about constructability?
I don't think that's a major issue.
You do not.
I do not.
So,
It's gonna be more difficult to construct, because again, but, you know, once it's constructed, it's gonna be there, and I don't think that is a significant factor, in my opinion.
you don't think so?
No,
If I told you there were high tension wires running across to Hackensack along the frontage, if the frontage is small enough, because again, it's a 6-story structure, billboard 60 feet, you have to put a foundation in that small area, 10 by 10. So you have to excavate or drill
So you'd have a pretty big piece of equipment to do that. Then you would have to crane in. How would you physically get there? Because you don't own to the left. That's the adjacent property that's in opposition to this. You don't own to the rear, because again, that's your client. Would you shut down Marginal Road?
I
And change
don't know
both
how it would be done, but I don't think that is the focus of the proofs that are needed for a variance. It's, what you're talking about simply emphasizes
That it's
that
overbuilt.
this site is already overcrowded.
That's what
and
I'm trying to say.
That's why you gotta do gymnastics.
If you had more room on the site, wouldn't you have all your construction equipment on the site when you built it?
Well, all I can say is it would be easier if you didn't have to do gymnastics because of the existing building. And I don't, usually the mode of construction is not necessarily the focal point of variances, but here, in my opinion, it just emphasizes the fact that this site is already fully developed, and it makes it more difficult to construct a
What
billboard.
I'm trying to say is, to do this in a practical standpoint, you physically can't do it on this site. Unless other properties come into it.
That's not my area of expertise.
Okay.
Well, I'm educated as an engineer.
You
I don't
said you're a
practice.
civil engineer. That's the first statement you made. From Rutgers.
But that doesn't answer all questions.
I got you. Okay, thank you.
Before I turn it over to the officer, one question I do have is, in your professional opinion as a planner, is there any impact on light, air, open space from this?
Well, it clearly, the reason you have height limits in your zoning ordinance is that, you want to protect a certain amount of open space. And here, this will be the tallest structure in the area. It has a volume to it, and it happens to be positioned between my client's rooftop amenity spaces and the view of the New York skyline. So if it complied with the height, that would not occur, but the answer is the applicant is very much exceeding the height. And again, the fact that this cantilever is over part of the building, in my opinion, adds to the total volume that you see.
That's correct.
Yeah, first, on your handout, page 2, just to get a frame of reference here. Let's say, image on the top. The height of that building, I mean, we're looking at 28 to 30 feet, something like that?
Well, with the parapet, it's probably closer to 35, I would suspect.
Okay, so then the sign itself would be 25 feet above,
No, but actually, I'm gonna take back, probably the first floor, yeah,
a little short.
yeah, I mean, without, my recollection is you don't measure to the parapet, but again, I think the building is potentially conforming to 35 feet, but the top of the billboard is could be 60
It's
feet.
gonna be 25 feet above that building.
Yes,
So as you're walking, like you look at, the lower image, as you're walking along there, that facade is gonna look like it's almost twice as high. It's gonna add 25 feet to that.
I didn't do it proportionally, I'm not an architect on this, but what's important to me is that this is a structure that is, 1/3 of the front yard. It's in your face in terms of people driving or walking on Route 4.
Now, quick question, you mentioned there's no hardships, so the C variance, we need to show beneficial impact, right? It has to.
Well, the applicant has to show that there's one or more purposes in the municipal land use law that are advanced.
So, and it wants to substantially outweigh the detriment.
They're independent, with C variances, there's that balancing test or with inherently beneficial is there's really not a balancing test here. They're two separate groups. There are three things that the applicant has to do. Is there a public purpose that's advanced? Number one. is the use particularly suited to the property? And independent of that, can it be granted without substantial detriment to the public good? And to me, that's blocking views.
Right.
Or is there substantial impairment to the zone plan and zoning ordinance? And in my opinion, there is, because of the importance of aesthetics and the fact that it is so much taller than what the zoning ordinance anticipated.
From the perspective of the beneficial impact. I think you testified that, the earlier testimony, the applicant really didn't meet that because the way communications impact.
Well, he's saying it promotes business use, and that's wonderful. And, you know, that doesn't mean you put a business in a residential zone. If there are other things to consider other than just promoting business.
Right, so you've got that as the possible positive impact. And balancing against that the safety issues, the loss of light, view, aesthetics, and all of those different.
I don't think the applicant meets any three of the proofs. There's no public purpose that's advanced, just because it's a business use is not under the municipal, and the business use had to be in an appropriate location. Just because it's a business use, because it's on a crowded site, in my opinion, there are none of those two purposes under Medici are advanced. And I think independently, this is detrimental to the public good because it's so tall, the tallest thing in the area. And because it detracts from the purpose of the master plan, which is to promote aesthetics. And again, it's personal to my client because he's gonna look at the back of this billboard, but there's not supposed to be something that tall in this area. And he is more offended because the fact is he went to the nth degree to market an office building with a rooftop amenity space. And it happens to be oriented toward the New York City skyline, and he's gonna be able to, critique the integrity of the structure of the billboard, because that's what he's gonna see. It's gonna be in the middle of his view of the New York skyline.
Thank you.
Any other questions from the board or?
Just have a question. I don't know who this questioner is for, and it goes back to Mr. Costa's question about constructability. I hadn't really considered the power lines, and I'm looking at Google Maps and seeing how close the power lines are to the proposed billboard. Are there any construction guidelines or codes that would prevent a structure being built a certain distance from the power lines? I don't know who to ask that to.
I don't know of any that, obviously the utility company would be concerned, but I don't know of any local code that you have. There may be something that comes from the Uniform Construction Code, but I don't know any local code that you have that would say, you can't construct within so many feet of a high tension power line.
There is
It's
a
approximate.
OSHA code, federal OSHA code. I
Yeah,
don't know the distance.
10
but
feet.
10 feet, that you cannot construct with it.
Do we know how close this is to that power line?
11 feet, I believe.
We will certainly comply with, we would comply with it as a condition of approval. I don't believe you could even give us, if we couldn't build it and you approved it, it would just, it's definitely a condition of approval, and we would need it.
Okay, yeah, because I'm just looking, we have a couple power lines that are right there. Beyond that code, is there a concern for our municipality to have something built so close, or do we not really have a say in something like that?
Well, obviously, they would need a building permit. Whether this gets approved at this level, whether it gets in a lawsuit or whatever and gets done that way, they still have to pull a building. They still have to do foundations, they still have to do all the above.
Yeah, it's not an ML concern,
It's not.
it's a building.
Again, the only reason I asked that question earlier was when you said unsuitable and overdeveloped, and that's what you kept harping.
Again,
The only reason I was
underscores-
going back to that, just to clarify the record, was to physically build this. I never got that answer, like, how do you do it? I mean, I think.
Not a zone, not a
How
zoning
do you
issue,
do
but the fact that you gotta do gymnastics, in my opinion, just emphasizes the fact that the site is already overbuilt. And this goes an nth degree further.
Well, I guess you weren't here, but maybe you were with Mr. McDonough. And again, this is last, take the microphone away from me.
It's not on anyone.
I asked him about a building in Bogota, New Jersey, where I happen to be the engineer. And he was the planner on that project, and it's on, roughly on Route 80. And that billboard goes right through the center of that building. And maybe they did it for setback reasons or whatever it is, but you could build this through the center of the building.
Well, that's not the applicant's proposal.
I understand that,
That's the only thing I looked at,
but you could do
except that it would extend the height limit. It would be in violation. This building is
it.
probably.
No, it would still do that, but I'm saying it would be, you could physically, and then
That's
put it
beyond
within
my
setbacks.
expertise
I understand.
to say.
But you could do that, and you could bring it down to 35 feet. We went over that at the last meeting. But you block their windows and their light and their building, but you could do it.
Well, yes, but that's not what the proposal is. I
understand what the proposal is or isn't, but they're requesting certain things with setback and height and all the above, and that's the only reason I'm saying.
My understanding is it's not your job, respectfully, to solve the applicant's problem.
I'm
You
not
have an
trying-
applicant before you, they have the burden of proof. If they haven't met it, they don't deserve an approval.
If I may, Mr. Chair, just wanted to do one follow-up to Mr. Gibbons' question. So I'm personally aware that there are a number of contractors that interpret that OSHA rule that we just talked about, 10 feet construction within high tension power line, to not place workers within that 10-foot zone. That's how a lot of contractors will interpret it. It's not only the finished product,
Correct.
it's actually placing workers in between. There's the potential for hardening into danger zone.
Thank you.
Awesome. All right. Thank you. Thank you, Mr. Stick. Just a few quick questions for you. You're not a professional engineer, correct? You're not here tonight as a.
I'm only educated as an engineer. I don't practice as an engineer.
Understandable. So you're not testifying that the structure in any way encroaches on adjacent property?
I didn't say that. I didn't testify about any encroachment.
And you did not testify that it blocks any access to the neighboring properties?
Correct.
And you didn't testify that it interferes with any emergency access?
Correct.
And your opinion is mostly that the bulk variances are excessive, the bulk deviations from the borough code?
My opinion is everything that I said.
Yeah, so you didn't identify any safety impacts tied to the bulk variances?
I did not identify them in my testimony.
So your testimony is largely one of scale and the visual character of the billboard?
My testimony is that the applicant's planner has not met its burden of proof, and there are multiple factors to that.
And it's also your testimony that 35 feet is the maximum height in the C2 zone?
Yes,
Now, is there any zone in the municipality that you're aware of that a billboard is permitted?
at the current time, no.
So any billboard would require variance relief?
Yes,
And so there's no bulk standards for a billboard?
not specifically for a billboard, but a billboard going into a zone, you take those standards into account.
So the only way a billboard could come to a river edge would be through these variance?
Yes,
And that determination must be made on a site-specific basis under the MLUO?
in my opinion, yes.
That's all I have.
No questions, Mr. Stack. Thank you.
Anybody in the public wishing to ask any questions?
Mr. Falcon, sir, do you want to make a closing argument? Mr. Charles, do you want to make a closing argument? Or that's-
I think, I
Yeah, you
prefer,
go last.
yeah.
You want to make your change go first?
Happy to go first, if you'd like me to go first.
Liz,
That's fine.
Been here for 7 months.
He's taking copious notes.
Good evening, board members. Just put your hands on record. Yeah.
Good evening, Jeffrey James, Austin Kyle Foley for, Route 4 Main Street LLC, State of Kent Revenue Trustee, and 41 Grand Avenue LLC. Members of the board, the applicant seeks multiple D variances, but has not carried their burden. On the D1 variances, the billboard does not inherently serve public good, nor does it promote the general welfare, leaving the board with only one conclusion. The proposed site is not particularly suitable. The applicant's planner testified that the billboard advances purpose G of municipal land use law regarding sufficient space and appropriate locations. But that is countered by the fact that the applicant seeks a height variance. The applicant's planner admitted on cross-examination that the height variance needed was because of the existing site conditions, the building, not the billboard use itself. This was hit home by applicant's planner also admitting that a 35-foot billboard could service non-Route 4 internal commercial corridors in the borough. The applicant's planner also admitted as his assertion that the application advances purpose H of municipal land use law regarding free flow of traffic. It was weak because the applicant's traffic engineer never testified that the billboard decreases the flow of traffic. Further, the applicant's traffic engineer could not answer as to the impact or distraction time of drivers in parking lots, such as those on the bike lines, caused by billboards. Applicant's planner further testified that purpose M of municipal land use law regarding the efficient use of land, but this is a property that is already intensely, in fact, over intensely, as Mr. Sec testified. Further, how can it be efficient use of land when the borough's ordinances already outright and specifically prohibit billboards? As for the negative criteria, the applicant's traffic engineer testified on cross-examination that adding another sign to drivers' view shed along Route 4 would have minimal impact, but it simply does not follow that a billboard that forces people to look up in a already signed-in area along a several lane highway would have minimal impact. Finally, as for the height variance, the applicant has created their own hardship by proposing a billboard that exceeds the zone's max height almost twofold. The height is only needed, and I say needed lightly here, so that the applicant can service Route 4 from the site. But the design that generates the applicants the most money does not carry the day on a D6 height variance application. 41 Grand Avenue is an unsuitable location for the proposed billboard. We respectfully urge the board to deny the application and thank the board for its time and consideration. Thank you.
Thank you.
So I too would like to thank, again, Charles Sullivan for the record. I too would like to thank the board for your time and consideration over the course of these hearings. I know they have been extensive and where members have certainly listened intently as I've observed the board members. So while the development application is important to any applicant, it's equally important to the opposition. While that applicant is trying to create value, the opposition is actually trying to preserve value. They're trying to preserve their asset. So in that sense, when they argue that the opposition's interest is more important than the applicant's interest, they already have something and they don't want it being taken away. Whereas the applicant's trying to, climb the hill and trying to obtain approval to get something. So the two interests are certainly not aligned,
but they're certainly, important to each, and I would argue that the opposition's, interest, especially in this particular case, is more important. Now, this is the type of application that needed a lot of detail to convince the board, because there was significant proofs, as you heard from Mr. Steck, there was significant hurdles with the site. And the applicant's planning testimony really needed to drill down and be specific, in my opinion, to convince this board to, approve this application. Unfortunately, in my opinion, the opposite was done. It was a total gloss over of the proofs. It was really done in a summary fashion. And that does not get you to the finish line as it relates to an applicant's meeting the burden of proof. Fundamentally, the applicant needs a use variance. You've heard that over and over again for the proposed billboard. Now, there's been some pre-hearing communication, I think it was mentioned here once or twice in some other hearings about, the constitutionality. And as the town's ordinance that prohibits billboards in all zones pass the constitutionality test. And again, it's my opinion that that's really not for this board. I mean, that's for the courts to decide. The mayor and council could have withdrawn the ordinance if the applicant requested, if they thought it was unconstitutional. But I don't think this board has the legal authority to determine constitutionality. It's what's on the record, and that's what this board has to go by. But casting that aside, if you say, well, maybe the courts will cast this as being unconstitutional. Casting that aside, the borough zoning code in the C2 zone does not allow billboards. It's not a permitted use. So if it's not a permitted use, it's a prohibited use. This case law, it talks about that. If it's not an express provision in your ordinance that says if it's not permitted, it's prohibited, and some towns have that particular ordinance. If yours doesn't expressly say that, there is case law, and it says, although a borough zoning code may be permissive, the usual rule of construction of zoning ordinances is that where use is not expressly provided for, it's prohibited. It's actually a Borough of Northvale case from 1987. So either way, whether it's, you want to, rely on the, it's prohibited in all zones, that particular section, or the fact that it's not listed as a permitted use in the C2 zone, it's clearly they need a use variance. I mean, I don't think there's any question about that. I think the applicant has certainly submitted to that. And the applicant has also submitted to the fact that there's 2 permitted uses on the site, which needs a second use variance. These add up. These are important because, again, the gloss over when we talk about the proofs that are needed, it's not need all these use variances, but here's the testimony, because each use variance is different. And the applicant's plan should talk about this use variance and how he met the burden of proof related to this use variance. And this use variance and how the burden of proof relates and his testimony relates to that. And you don't just throw it all in like, a cake batter and say, well, my testimony applies to all the use variances. So they're different, right? 2 principal uses on the site, like Mr. Steck said, the site's overdeveloped. That requires a certain level of proof. Being prohibited in the zone, of the C2 zone, is a certain totally different circumstances that have to be considered by the board, and that you have to hear the applicant's testimony as it relates to that use variance. Going a little further, when I cross-examined the applicant's planner, I brought up section 416-45 of the Borough Code. And that says locations where signs are prohibited. I think we would all agree the billboard's a sign, and Mr. McDonough, the applicant's planner, also agreed that the billboard is a sign. So this section is applicable. All right, where are signs, billboards prohibited? Now, we're not talking about what zones. This becomes site specific. Paragraph D says doesn't project into the side yard. I mean, a setback, a yard setback. Not necessarily side yard setback. And paragraph C of section 416-45 prohibits signs or billboards to extend above the roof. And you probably say, well, why shall I bring this up? We've heard a lot of testimony about that. But when I asked Mr. McDonough, how is he categorizing these variances? Are these C variances, bulk variances? Typically, when you say, we're going to project, we're going to
put a building in the side yard, being a side yard setback, that's a C variance, a bulk variance. Or potentially some heights, if you're, within 10 feet or 10%, that could be classified as a C variance. But like I said, look at this section, because it's not in the bulk section it's not in the schedule, it's not in the bulk section variances of the Borough Code. How do you classify these? He didn't say they were C variances, he wouldn't agree to that. He wouldn't agree that they were additional use variances. All he said is they got to all be considered together. So again, what does that mean? It means just throw everything into the soup and let me give some generic testimony on all of these variances. I would actually submit that because the word prohibited is used, the infringement into the required setback that prohibits signs being there is prohibited. You need a use variance for that. It says, your ordinance says, do not put a sign in the setback. Okay, not that the sign should be 6 feet off the property line. It says don't put a sign in. And maybe, this goes to Mr. Costa, that's been talking about the ice. People, setbacks are for open space. People walk in open space. They garden in open space, and they mow grass in open space. Maybe that's the intent of not putting a sign, an elevated sign in the setback because of, you want safety and free from falling objects. So maybe that's the intent, in terms of where Mr. Costa was going with some of this questioning. So again, I would submit, in my position, that this is a third use variance. We're being prohibited from being inside yard. It's a fourth use variance for projecting over a building. As Mr. Steck said, in his opinion, this is 2 billboards. If you agree with that opinion, and I do, you double the magnitude of each of these 4 use variances, because you have 2 billboards that are being proposed. So again, when you interpret the zoning ordinance, we're talking about, this paragraph B and paragraph C of section 416 and dash 45 about what I was just talking about, the setback and the sign over the roof. The courts talk about, look at it, what's the objectives of the legislation or your code, and use common sense. That's some court language. It says, the spirit of the legislation prevails over its actual terms. So what is the spirit of this legislation? Clearly, the term is prohibited. And the legislative intent is saying, we don't want billboards, not necessarily in the zones, we're past that use variance. We don't want signs and billboards over a roof, and we don't want billboards in a setback. That's very clear. So I think that provision could be interpreted easily to be requiring use variances. So let's talk about the standard of use variance review real quick. I did ask Mr. Steck on the follow-up. The most recent Supreme Court case, maybe there have been some others, but the more recent one that people talk about is the Price, it's called the Price case from 2013, and it clarified really what site suitability means and how it should interpret it. There was the Medici case, which is a Supreme Court case, and then there was a lot of other cases. But the price case is but let's really talk about what site suitability means. And again, what the Price case clearly tried to articulate was, there must be a finding that the general welfare is served because the use is particularly fitted to the location for which the variance is sought. It's particularly suitable, particularly fit. The Price Court said the analysis has to be fact specific, site sensitive. That's the words of the Supreme Court. And maybe more importantly, equally importantly, the court said particularly suitability does not equate to unique suitability. I'll explain that in a minute. So for a site to be particularly suitable doesn't mean it's uniquely suitable. And the reason I say that is Mr. McDonough's testimony talked about the limited number of properties up and down Route 4 where it's large enough for a billboard to go. So he was trying to establish that this site was uniquely suitable, not particularly suitable. Because he was saying that, there's no other, there are no other sites, and like Mr. Steck said, he didn't get into any specifics related to these other sites, it was again a gloss over. But he was trying to establish that this site is uniquely suitable as it relates to other potential sites in River Edge on Route 4 that would be appropriate for building. That's not the standard. It's particularly suitable. It's fact-specific site sensitivity. There was no testimony from Mr. McDonough as to why the site is particularly suited for a billboard that's not allowed in the zone. Why the site is particularly suited for two principal uses, the office building and a billboard. There's no testimony from Mr. McDonough why a use variance, he agreed the use variance, the site's particularly suitable to have a sign, a billboard over a roof or in a yard setback. There was no, as the price court said, no fact specific and site sensitive testimony for him to advance these proofs on behalf of the client. So applicant's plan, Mr. McDonough, he did summarize. This is his quote. The case law tells us to look at the physical characteristics of this property, work property, and why it lends itself to the use. So he was on the right track. He summarized it, the standard, but that's where it ended. He didn't get into the site specifics, fact sensitive. In addition, the applicant's plan had to testify as it relates to the negative criteria. I know this board is familiar with the negative criteria in the first column and the second column. And really, what I want to focus on, and I did ask this when I first examined this, is the enhanced quality of proof. That's always overlooked. You gotta testify, you gotta prove the negative criteria, and demonstrate it's in accordance with the enhanced quality of proof. And what's the enhanced quality of proof? Is you gotta reconcile why the proposed use is omitted from the zoning ordinance or the master plan. So a case, an example to give you, and I actually used this some way back when. If Hackensack Hospital expands, obviously they can expand, but if they expand, there's 1,000 new employees, nurses, doctors, technicians, whoever, that are going to be employed there. It may not be in the city of Hackensack master plan to allow multifamily residential close to the hospital. It may not be in their zoning code, it may not be in their master plan, but Hackensack announces or starts to build a new wing that's going to employ 1,000 people. There's your reconciliation. Why is it omitted? Well, because there may have not been mayor and council when they drafted the master plan, or the planning board when they drafted the master plan and approved it, didn't see a need in that particular area. Circumstances have changed. And, there's the proof. I can reconcile why I need a use variance for multifamily in proximity to the hospital, because, there's circumstances have changed and there's more employment there. So that's really what the whole thing about the enhanced quality proof is. And generally that's done through, the town's master plan objectives, right? Purposes and objectives. And when I asked Mr. McDonough that, he said, I did list a number of master plan objectives. But he listed them, and he agreed to this, he listed them in support of a positive criteria, not as it relates to the negative criteria in the enhanced quality proof. So again, why is that significant? Because he missed it? He didn't meet the burden of proof on that, because that's part of the standard. You gotta put that burden of proof on the record. And then lastly, I'm really here for my client and his rooftop amenity that everybody spoke about.
But lastly is, again, one of the, negative criteria prongs is no substantial detriment to the character of the neighborhood or, the impact, substantial detriment to neighboring properties. I think you heard, my client's architect, Mr. Letty, talk about, in his opinion, from an architectural standpoint, there is a substantial detriment to the property. From Mr. Steck's testimony, he believes that there's a substantial detriment. I mean, clearly a billboard towering over the neighborhood twice the height that's permitted. It's not only a substantial detriment to my client's property, but as Mr. Steck said, to, that entire neighborhood and, one could argue even the whole character of the borough of River Edge. So Mr. Steck kind of concluded that he believes the site is particularly unsuited. I agree. The board is really faced with competing testimonies of Mr. Steck and Mr. McDonough, they're both licensed professional planners, so they both very well, even though Mr. Steck, all departments in McDonough's testimony, I've worked with both those in Mr. McDonough's testimony, Mr. McDonough is a very good planner. But the testimony is on the record, and when the board has competing testimony, you gotta look at the credibility of the two witnesses, and the testimony that they put on the record, and you gotta weigh that credibility to see, who you gonna believe, who you gonna put more weight on in terms of, weighing your opinion. So, my summation was really to highlight some of the key areas. There's many, many more, in my opinion, but, I think highlighting these key areas clearly shows that the applicant has fell well short of meeting its burden of proof on the variances that are required. Okay, thank you for your documentation.
Sorrow? All right. I'd like to just thank the board, the chairman, members, and the staff. It's been a long trip. We've been here for a while, but now we're at the end. The applicant has presented sworn testimony from its licensed engineer, a licensed traffic engineer, and a licensed planner. The site has received an NJDOT permit for the billboard. There's been no competing traffic engineering testimony, accident data, or safety issues put onto this record. We recognize that the billboard is not a permitted use anywhere in the borough, which is why this applicant requires the B1 use variance together with the height variance and bulk relief. Because the ordinance contains no dimensional standards specific to billboards, the bulk relief sought is measured against the building standards that were not drafted for freestanding signs. This property is located along Route 4, State Highway Commercial Corridor under NJDOT jurisdiction. The C2 district contemplates substantial commercial development and vertical structures, some of which exceed 35 feet. The requested idea relates to a freestanding structure along a highway corridor, not to additional habitable space, increased building mass, or intensified site use. The sworn testimony establishes that this Route 4 location was particularly suited for the purpose. The requested dimensional relief does not establish harm, and the concerns raised are primarily to visibility and aesthetics from a neighboring property. There is no competent evidence of any safety risk, no increase in traffic generation, no impact on site access, and no change to the intensity of the use of the subject property. The proposed structure does not increase occupancy, demand on municipal services, or strain on the borough's infrastructure. And we disagree with the objectors and believe that the record strongly reflects that the applicant has met its burden and has specifically identified the negative criteria, and the record reflects that. At this time, we respectfully request that the board close the record and proceed to a vote. Thank you.
Awesome. Further final questions from the board?
I'll just give a brief, close. I'm not going to rehash the testimony, but I think the board in its deliberations, whether for or against the application, should just focus on the statutory criteria that was mentioned. So I would, even though we're not going to get into the constitutionality aspect of this, I would note for the record that our ordinance, our definition of billboards is nearly identical to the one in Mount Laurel, New Jersey, which was upheld by the Appellate Division, as well as the one in Austin, Texas, which was upheld by the U.S. Supreme Court. That aside, I would suggest that the board not reference that prohibition in its deliberation, but just acknowledge that by virtue of billboards not being permitted, therefore requires D1 variance relief anyway, and that municipalities aren't required to permit billboards in all cases. So, again, focusing on statutory criteria, we have the D1 use variance issues at hand. And again, the applicant's test was to, and the burden being on them to demonstrate that one, it advanced purpose, at least one purpose of the MLUL. We heard testimony to that end, that addresses issues of site suitability. And in essence, that relates to whether or not the site can accommodate the use, as well as the negative criteria. And as we've heard, the negative criteria in this case has the enhanced burden of proof that the applicant must, one, demonstrate that the granting of relief would not result in a substantial detriment to the public good, and the enhanced burden being that the granting of relief would not substantially impair the intent and purpose of the master plan and zoning ordinance, all aspects of the master plan and zoning ordinance. Then we have a number of C variances. Again, it's my opinion that they're, not necessarily codified because the ordinance doesn't contemplate them, but nevertheless, there are instances where a billboard could be compliant. It's just that the site happens to be developed. And in that case, I still believe that the C1 and C2 criteria have a place in these deliberations. Again, the C1 criteria relating to whether or not there are any hardships that prevent the applicant from complying, and C2, whether there are any public benefits that outweigh any detriments. We've certainly talked quite a bit about impacts to surrounding development, the office building in particular, the three objectors that participated in this application. And, while the applicant kind of glosses over that, there was no credible testimony, there was also no credible, from my perspective, information, as far as shadow studies, renderings from different perspectives, and a comprehensive traffic analysis that would suggest that the application's impact free. I think that's a question for the board. Are there no impacts being generated from this? And how does that weigh against any perceived benefits from this? So again, I'll just reiterate, I would focus on the statutory criteria in your deliberation.
Right.
Is there, as far as proceeding, should we consider a motion that covers the variances, all the variances that were requested, or do we look at the D variance on that, and then D variance as they become required?
So do we have to move?
So my suggestion would be that somebody either make a motion to approve or, and if you feel like setting forth the reasons why you approve or deny, that's fine. We have an expansive record. I have 26 pages of notes. And you can make a motion with or without reasons. I will draft the resolution accordingly for your consideration, review it. If I miss something, add it and change it. But you don't need to break this out variance by variance. They need all of the variances in order.
So the motion to consider.
I make a motion that we accept and approve the variances that have been requested.
Motion to approve the application.
There's a second.
There is no second, so
I'll move to deny the application.
I mean, it wasn't second, so the motion dies.
Okay. So now, first motion to approve is approved. Now we have a motion to deny the application. Mr. Canigo, is there a second?
Second.
There's a second. Mr. Coe.
So you can have discussion if you like, but it's up to you. I don't know what the board's, typical procedures are.
Once we motion second action. We have no for deliberation at this point. Need for it.
Yeah, you can proceed to a vote.
So we have first from, we have a motion from Mr. Canino, seconded by Mr. Godier. You call the roll.
Just to be clear, we're saying yes to deny and no to accept, or not to.
The motion is to deny approval of the application, so your vote in the affirmative is a vote to deny.
And there's no need for discussion because of all the testimony already provided?
I'll call the roll. Start with Mr. Craig. Yes. Ms. Vaughn.
Yes.
Ms. Gibbs.
Yes.
Mr. Canino.
Yes.
Mr. Sala.
Yes.
Mr. Godier.
Yes.
Ms. Lee.
Yes.
And I will vote in the affirmative as well. Okay. Motion passes, the application for approval is denied. This-
Thank you, council. Thank you. Did a really good job, and you were all polite to each other. Thank you.
Thank you all.
Thank you. Thank you.
Not done yet?
I'm confused.
And I'd just like to, think over, or, you know, what, you just discussing, first that, the board, and our professionals as well, and the organization is very well. And she come in.
I like
it. Final decision is very.
Mr. Chairman, I just want to put on the record, I apologize for Mr. Lehman. I know him for 20 years and I more than apologize, maybe 30 years. Maybe I'm just too old.
Take the microphone.
To complete our agenda for the evening, council board, would anybody in the public who wishes to make a decision at this time?
No, there's nobody else. Like, did you guys approve the resolution to the next school board that are going to take council on tonight? But. That's pretty good.
I know that.
Yeah,
sure.
Take care.
All right, if there's nothing further at this time, for motion to close the meeting. So moved. Mr. Gibbs, there's a second, all in favor? Aye. Opposed, abstained? Adjourned, 10:16.
Yeah.
What was that, Mr. Gibbons and Mr. Craig?
You have to cut this cord, and I'm up with